Hello everyone, how are you all? I hope all of you are doing well. I hope all of you are ready with your preparation. Also, you all would be, I hope you are all high on your revision. Yes, and you are not picking up any new topics, you're not experimenting anything else now because it's like we have only 16 days, technically 15 days left for the examination. So, this is high time wherein you should only focus on revision, right? Now, uh, in legal reasoning section, the most notorious kind of passages are unfamiliar passages, right? So everybody is mostly worried about how to tackle those passages and all of that. So just to solve that or make it easier, I have started this series, right? So you have been getting these important legal updates since last 2 months, right? And we can expect that there would be some passages that would be surrounding around these legal developments that are going around us, right? So let's quickly start with today's session, and I'm also hoping that you have gone through our previous legal updates. Also, you can go check the playlist, yes, or else I'll put the link of the playlist in the description box below. Yes, let's start with today's session, starting with the most interesting one, that is about the sedition law. Everybody who is following newspaper would be knowing that for at least for every other action of any individual against the government uh, is always covered under sedition law, है ना? हर चीज को सेडिशन लॉ में आजकल एक्सट्रैक्ट कर लिया जाता है. Now what is it and what has happened with regard to this? So basically Supreme Court has taken a stance now. Supreme Court has clearly said कि अब no more FIR would be filed with regard to sedition laws. And secondly, all those cases that are pending in the court, they are also supposed to be kept on hold. So basically, they have asked the government to revisit these set of laws because they are very old laws, right? They have been, we have been following these laws since the time of Britishers. कब से फॉलो कर रहे, बहुत पुराने लॉज हैं, and they were very relevant in those time. But for now, that is what Supreme Court has said, so as to check all the provision whether these provisions should be followed now in today's scenario or not, or are there any requirements of amendments? Of course, there are certain requirements that Supreme Court suggests, but now the government has been set to do that. Yes. Now, our motto is here to understand about law, right? That is sedition law. That is covered under Section 124A of IPC. It is a penal, there are penal charges that are imposed against a person who on whom we file the charges of sedition. Now, what is sedition? Sedition means when a person does something, such an act, okay, through which either he or she is showing some disaffection against government, and that is impacting the public, or he or she is merely simply spreading the hatred against the government in the public. Okay, so it's just that if you are doing anything against the government, that is impacting the entire, or that is influencing actually the entire public, in such case sedition law is attractive. Okay. Now, there's again an old law. In 1962, there was this Kedarnath case wherein Supreme Court upheld the validity of constitutional validity of this Section 124A. Then also such constitutional validity was challenged and it was upheld. Right now, again, Supreme Court has taken up this matter, and let's see what happens in future. But for now, the only important thing for us to note is about sedition laws. Okay, now these are non-bailable. The punishment with regard to these is that it is non-bailable. First of all, non-bailable means you cannot avail bail. So it becomes rigorous, right? It becomes very hard law. First, second is punishment is also very grave here. It can last up to lifetime. Okay, so you can be given lifetime also if it is found that you are spreading hatred against government. Okay, not only that, if sedition charges are attracted in your case, in such case you would be barred from taking any government job. वहाँ से भी हटा देते हैं. Second and last of all is that if you have a passport, okay, so that will be seized, so you cannot move out of the country. So again, that is also something that is painful. So all of these are very rigorous, very hard punishment, right? And that is why, and in such case, it becomes very important to keep a check on such laws, and hence Supreme Court has taken stance in this case. Okay, moving on to next question, that is about marital rape. Again, this is also one of the hot topics that we have been following since like the last few months, and actually this topic has been a hot topic since last several years. Okay, so we have been discussing about it. There are a lot of law commission, there are a lot of amendments, there are a lot of committees. I mean, they all have given some or other recommendation, their own suggestion, their own points on marital rape, but nothing has been implemented so far. Okay, so now Delhi High Court, there was this case wherein constitutional validity of section 375, that section 375 actually talks about rape. Okay, now there is an exception to that rape, and that is marital rape. Okay, for that constitutional validity was challenged in High Court, where in High Court there were two judges and both of them gave different opinions. So at the end we did not get anything that is solid with regard to the marital rape, right? So, Section 375 talks about the rape. There are two exceptions. First one is marital rape, and second one is just in case if there is any medical procedure that is required, medical intervention that is required. In such case, also you cannot attract rape, right? Now, there are what? How do we keep a check on marital rape now in the present scenario? Yes. So there is this law, Domestic Violence Act, that came in 2005, that in some indirect way talks about marital rape, okay, by any or any sexual abuse. Okay, so they talk about sexual abuse, marital rape under domestic violence. Okay, so that comes under another ambit of domestic violence. It may be in a live-in relationship or it may be in a marriage relationship. Okay, so both of them are covered under this law. Apart from that, the the darker side of this is that no criminal proceeding can be initiated in this case under domestic violence law. If there is any marital rape that is found, criminal proceeding is not attracted. Only civil proceeding is attracted, and when proceeding is attracted, only civil remedy can be availed. Right. So that is something that is you know that has to be rectified or that has to be checked in some way, and that is why this has been a hot topic. There are a lot of discussions that are going uh, around on this topic. Now, when it comes to appointment in the Supreme Court or in any Premier High Court, in such case, such information, such things also becomes very important. So there is this recent news that there are two judges who have been appointed in Supreme Court. Okay, and one of them was the Chief Justice of Guwahati High Court. Okay, so Justice Jamshed Pardiwala and Justice Sudhanshu Dhulia. So both of them have been appointed as judges. Now, what this information is important. Apart from that, it is also important as to how are they appointed. Okay, under what provision, what is the procedure, all of that. Now, for their appointment, there is an Article 124 that takes care of it. Article 124 of Constitution. Okay, so that talks about the appointment of Supreme Court judges. Now, for that, President appoints it, but on the advice of Collegium. Okay, now what is the Collegium here? First of all, there would be at least one Chief Justice, and here our Chief Justice was N.V. Ramana, right? Justice N.V. Ramana, and there would be two judges or more than that. So here are there were Supreme Court judges, U. Lalit, we had D.Y. Chandrachud, we had Nageshwar Rao. So all of them came together, and that was the Collegium. They recommended these two names for the Supreme Court judges. Okay, yes. Moving on to the next one. Okay, now there is this new step or say new direction that has been taken by new action that has been taken by SEBI. Okay, now what is SEBI? Securities and Exchange Board of India. Now that there is a huge upsurge that we have seen in last few years, basically since the COVID, I would say, huge upsurge in the security exchange, in the stock exchange, right, in the depository, all of this. Maybe because of the financial crisis, or there can be other reasons also. So SEBI recognized it. Okay. Now, wherever there would be more involvement of people, it will become prone to certain crimes, right? So, in order to check upon these wrongful activities, SEBI came up with a circular, a notification basically, okay, wherein it talks about the cyber security and cyber resilience for MII. MII means Market Infrastructure Institutions. Now, what is market infrastructure institution? Just a combination of stock exchanges plus depository plus clearing corporations. So these are all almost same. Stock exchanges, I hope you would be knowing about it. Depository means all the securities that are involved into stock market and stock exchanges, and clearing corporation means all those entities, all those institutions that are involved in stock exchanges, okay, that are taking part in it. So all these for keeping a check on all these activities of MIIs, SEBI has come up with a new circular, wherein it is mandating a cyber audit of all these MII at least twice uh, an year. Okay, so every year uh, they have to get their cyber audit done. Okay, that is first. Apart from that, they have to submit a declaration by the CEO of the company or by the CEO of the institution, saying that yes, we are complying to all the directions, all the notification, all the advisories, all the circulars of the SEBI. Okay. Apart from that, the SEBI also has given them time of only 10 days to submit the status of implementation of all these provision. Now, why does it become important for us? Why do we think these kind of legal update would be important? Because you can get a passage on it, right? So when there is any such development that goes around with regard to the financial law, right? The business law, or maybe SEBI law, or any some finances basically, right? So companies law. So in all these cases, such passages also can be expected in our examination, in our CLAT examination. So you can expect these kind of uh, passages. So I hope now, if you are faced with any such passage that talks about SEBI, it won't be a problem. That talks about MII, it won't be a problem. If it talks about stock exchange, I hope it won't be a problem. Now, SEBI, Securities and Exchange Board of India, it is the primary head body, okay, the uppermost body that takes care of all the security exchanges. Take it. Now, from where does it get the power to issue all these direction, to issue all these circulars and everything? It gets it from SEBI Act. Simple. There is a SEBI Act 1992. So that is what gives power to SEBI to keep a check on all these institutions and all these entities. Okay, I hope that is clear. Okay, moving on to the next one. Uh, there are 25 special codes that have been set up across India, particularly in some states, to take care of the pending check bounce cases. Okay. Now, I hope you know what is check bounce. So, basically, when I write a check to you of, say, 1 lakh rupees, okay, such check should render some money to you when you the go to the bank, right? If it doesn't render money to you because of some fault, maybe I don't have sufficient balance, or maybe I have stopped the person, some reason, because of some reason, if such uh, money is not given to you, if it is not rendered to you, in such case it would amount to check bounce. Okay, and that is offense in under our law. So that is what is check bounce, and I hope now if you get any passage on check bounce, it won't be a problem. Simple hai. Okay, there are certain exceptions to it. Of course, there are certain exceptions, but apart from that, talking about the basics, this is what it is. Okay, which means simple. I write a check to you to give you money. I tell you by next month on 5th of next month you'll get this amount. But when you go take that check to the bank on 5th of the next month, you don't receive that money. Okay, bank denies it. Bank denies it on certain ground. It can be insufficient fund. So if I don't have 1 lakh rupees in my account, I cannot write a check to you. As simple as that. I should not have written a check to you, right? Since I've given a check, it is a promise that I'll be giving you, you will be getting your money on the 5th of the next month. Since I breached it, that is an offense, as simple as that. Okay, so there are 20, there are actually lot of cases of pending of check bounce all over India. Okay, so I think there was some data few years back that showed that most number of cases, pending cases that the courts have, pertains to check bounce cases. Okay, there are family cases also, but mostly they are of check bounce cases, and hence such step was taken by Supreme Court. Supreme Court has set up 25 special courts in Maharashtra, in Rajasthan, in Gujarat, in Delhi, and in UP. Okay, so all the in all these places, uh, 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 25 special courts have been set up, and they will mostly be taking up those cases wherein they have received summon. Summon means the person has been sent a notice to call, to appear in the court. Okay, so either someone has been sent कि भाई आ जाओ कोर्ट में अपनी हाजिरी लगाओ, टेल मी व्हाट हैज हैपेंड, व्हाई हैव यू नॉट, why did you not pay, or at least give me your side of story. Okay, or the person has at least appeared through the lawyer or in person. Okay, so appearance should have been done in the court through lawyer, maybe on his own also, or on her own also. The person should have appeared in the court. Okay, so only those cases has to be adjudicated for now. This is what Supreme Court has notified. Okay, the last one for today is with regard to the action that has been taken by, Election Commission of India is planning to take certain action against the non-existent parties. Now, what are non-existent parties? In short, we call it RUP. Okay, RUPP means registered unrecognized political party. Means these are those parties, either they are newly registered, abhi register hua hai. Secondly, maybe they did not acquire, they did not secure enough number of votes so as to be called as state party. Okay, unko utne votes nahi mile. Third one is either they never contested election only, they never contested election. So if any of these uh, criteria is fulfilled, they will be called as unrecognized political party. As simple as that. Okay. Now, these kind of parties, why Election Commission is going to take action? Election Commission is going to see whether they are complying to all the statutory requirement that is mentioned in Representative of People's Act, right? RPA, in short. So that is what they are going to take care of. Now, when we talk about these unrecognized political party, they, on the very first instance, they don't have all the benefits that can be enjoyed by a registered party. Now, what is a registered party? Registered recognized party, right? What is a registered recognized party? Basically means state party or national party. As simple as that. Okay. Now, talking about Election Commission of India, Election Commission of India looks after the election of president, vice president, Lok Sabha, and Rajya Sabha. That's it. Okay. And with regard to constitution, it is a constitutional body because constitution talks about Election Commission of India under Article 324. Yes, and all their powers, their functions, all of them have been covered from Article 324 to Article 329. Okay. Talking about their salary, talking about their status, talking about their removal, all of them are equivalent to what's followed for Supreme Court judges. Okay, that's simple. So yes, that is it for today's session. I hope this would help you, and I also hope you would go through all the previous legal updates also, so that that is the best that you can do in order to tackle the unfamiliar passages, right? That is to reduce your chances of getting a surprise, right? So that you save your time, you save your energy, and at least you're not demotivated by just one passage. So yes, that is it for today's session, and you can subscribe to this channel if you want to, because we are going to come up with a lot of analysis for CLAT, a lot of content on CLAT, right? That would be useful for your upcoming examination for both CLAT and ALET actually. Okay, so yes, that is it for today's session. Thank you so much, everybody, and all the very best. Give your best, keep your calm, and I hope the day is your best day, right? Thank you so much, and bye.